If you are the victim of domestic violence, stalking, or sexual assault, you have a number of important housing rights here in Oregon. First, you can end your lease early to move to safety. Second, in some situations, you can force the person who is abusing you to move out of your home. Third, you have the right to change your locks. And lastly, you cannot be discriminated against because you are a victim of domestic violence, stalking, or sexual assault. In this video, we'll be talking more about each of these rights and what you can do if your rights are violated.
First, if you were a victim of domestic violence, sexual assault, or stalking in the last 3 months, you have the right to end your lease early with only 14 days' notice. Your immediate family members, which includes grandparents or a boyfriend or girlfriend, can also move with you. If you wish to end your lease, you must give your landlord written notice that you will be moving out. The notice should state that you were a victim of domestic violence in the last 3 months and that you will move out by a specific date. In your notice, you must also give the names of any immediate family members who will be moving with you. Along with this notice, you'll also need to give proof to your landlord that you were the victim of domestic violence, sexual assault, or stalking. You can use a police report, restraining order, criminal conviction, or a statement from a police officer, attorney, counselor, or advocate to prove that you were a victim. You can either personally deliver the notice to your landlord or send it by first-class mail. If you hand-deliver your notice to your landlord, your move-out date can be 14 days after the date you deliver your notice. If you mail your notice, then your move-out date must be 17 days after the date that you mail the notice. 14 days is the shortest amount of time you can give. You can always give a move-out date that is longer than 14 days away. If you provide your landlord with proper notice and documentation, your landlord cannot charge you an early termination fee, and you will only need to pay rent up to the move-out date in your notice. If your rental will be empty after you move out, you have a right to get your security deposit back within 31 days of your move-out date, minus any money the landlord keeps for repairs or other money you may owe them, such as late fees. If there are other tenants still living in the rental after you move out, you will have to wait until everyone has moved out of the rental before you can get your security deposit back.
If you wish to stay in your home, you may be able to force the person who is abusing you to move out by getting a restraining order. If the judge grants you a restraining order, the judge can also order the person abusing you to move out of your residence, but only if your name is on the rental agreement or you are married to that person. If your abuser is forced to move out, you are responsible for rent from the date they move out of your home. However, your landlord is not allowed to raise your rent, charge you a higher security deposit, or charge you any additional fees because your abuser moved out.
You can also change the locks on your rental to keep you safe. If the person who abused you does not live with you, you can change your locks at any time. You must give your landlord written notice and let them know that you've been the victim of domestic violence. You do not need to provide proof that you are a victim. If your landlord doesn't change your locks in a reasonable amount of time after you've given them notice, usually a day or two, you can change the locks on your own, but you must provide your landlord with a copy of the key. Regardless of whether you or your landlord have the locks changed, you will still have to pay for the new locks. If you live with the person who abused you, you are not allowed to change the locks until they move out and are removed from the rental agreement. If you get a restraining order and the order requires that the other person move out of the home, you can change your locks at any time after they have been served.
If you are a victim of domestic violence, stalking, or sexual assault, a landlord cannot discriminate against you. This means a landlord cannot evict you, threaten to evict you, increase your rent, treat you differently than other tenants, or deny or decrease services because you are a victim. So, if you violate your lease because of domestic violence, stalking, or sexual assault, your landlord cannot evict you for the violation. For example, you cannot be evicted for noise disturbances if a domestic violence incident disturbs neighbors during quiet hours, or for your abuser coming over without your permission and disturbing other people where you live. Your landlord also cannot evict you for criminal or police activity committed against you that is related to domestic violence, stalking, or sexual assault. For example, if the police have made multiple visits to your residence because of domestic violence incidents, your landlord cannot evict you for this. If you are living with a person who is abusing you and that person commits a criminal act of violence against you, your landlord can choose to evict the person who is abusing you. However, the landlord cannot evict both of you from the rental unit. Additionally, if you're looking for housing, a landlord cannot deny your rental application because you have been a victim. For example, a landlord cannot deny you based on a bad reference from a former landlord related to an incident of abuse, or because you've had an eviction on your record that was related to an incident of abuse. There are only 2 instances where a landlord is allowed to evict you for conduct related to domestic violence, stalking, or sexual assault. First, if the person abusing you was living with you without your landlord's permission, your landlord can lawfully evict you. Or, if you allow your abuser to remain on the property and they are a danger to other tenants, the landlord can also evict you. In both of these situations, your landlord must give you a written warning and provide you with an opportunity to fix the situation before they try to evict you.
If you are a victim of domestic violence, sexual assault, or stalking, your landlord cannot make you pay for damage to the rental that was caused by the person who abused you. This means that the landlord cannot make you pay for the damage while you live there, or make you pay for the damage by taking it out of your security deposit. If you provide your landlord or apartment manager with any information about the abuse you've experienced, they must keep it confidential. They cannot talk about it with any other tenants or landlords.
For more information about your housing rights in Oregon, you can read our Housing Rights for Survivors brochures on our website, OregonLawHelp.org. If your rights have been violated, you may wish to talk to an attorney. An attorney may recommend filing a lawsuit against your landlord, or if you're facing an eviction, an attorney might be able to prevent you from being evicted. If you would like to speak to an attorney, but you cannot afford one, you may be able to get free legal help from legal aid attorneys in Oregon. To find your local legal aid office, visit OregonLawHelp.org. You can click on the Use This Map option on the right side of the website to find the office that serves your county. If you can afford to pay an attorney, but do not know one, you can call the Oregon State Bar Lawyer Referral Service at 503-684-3763 or toll free at 1-800-452-7636. They can help you find an attorney that is familiar with your type of case.